Thank you. Please be seated. We're now back from recess to argue the second case on this morning's docket. Case number 127390. Again, this is State of Kansas ex rel. Chris Kobach, Attorney General Appellee versus Adam Kellogg, Catherine Redmond, Juliana Ophelia Gonzalez Wall, and Doe Intervenor Respondent 2 on behalf of her minor child, Helens. Would the council please state their appearances?
Good morning, Your Honors. Julie Murray for Intervenor Appellants. I'm joined here by DC Hegert, my co-counsel.
Thank you.
May it please the court, Solicitor General Anthony Powell appearing on behalf of the state, and with me is Assistant Solicitor General Ryan Ott.
Welcome back. All right. Thank you very much. This case has been scheduled for 20-ish minutes of oral argument per side. Would the appellants like any rebuttal?
Yes, Your Honor, we'd like to request 5 minutes.
5 minutes are granted. And with that, you may proceed.
Sorry if is that still working?
I believe it's
Yes.
working, yes.
Good morning, Your Honors. The preliminary injunction in this case has blocked a KDOR policy that was in effect for more than 14 years, at least, without incident. Since that policy has been enjoined, transgender Kansans, including my clients, seeking licenses have been forced to obtain, carry, and use driver's licenses that disclose their sex assigned at birth, rather than the gender that they live as in their communities and know themselves to be. Now, the Attorney General asked the court to conclude that all this is required by SB 180. But to get to his preferred reading of the statute, we would submit the court would effectively here have to take a red pen to the legislature's work, something that is not the place for this court, and instead is something that the legislature, I believe in the conversation earlier, could do itself should it want to. Now, to begin with, I want to focus on part of our statutory construction argument that I think has not come up so far to date, despite the back and forth this morning. And that is that SB 180 doesn't just define sex. It says that it applies only, quote, with respect to the application of an individual's biological sex, end quote. The driver's license statutes and KDOR's gender marker policies don't use the word sex. They don't use the word biological sex. They use the word gender. In light of this limiting language in SB 180 about biological sex, it makes no difference whether this court, as the Attorney General and the District Court believe, think that sex and gender are synonymous. However interchangeable those terms might be in daily life or in some statutory schemes, SB 180 does not just define sex. It says that it applies with, can you still hear me?
I can hear you, but I'm.
Oh, there you go. You got it. You can
All right,
see
we're
that.
back.
Make sure the
Okay.
green light is.
Yes.
It says that it applies only with respect to biological sex. And so I think what we can take from the plain language of the statute, although I would be the first to say the statute is not particularly well drafted, but what I do think is clear is that whatever the legislature was trying to get at, whether it was sports or something else, it used very particular language separate and apart from colloquially how we might use the word sex or how we might use the word gender. It said biological sex. And that is a unique term that is present in this statute and several other statutes that were adopted in the same session by the legislature. I think that is evidence that this was a considered judgment about the language that the legislature used there. And because of this limiting language, I would say to your Honor's questions this morning, you don't need to decide whether sex and gender are in fact interchangeable. You don't need to decide that for any other statute in Kansas. All you would need to decide, and I think this is under a plain reading of SB 180, is that the language saying that SB 180 applies pursuant to the application of an individual's biological sex is limiting language that forecloses its application to SB or to the driver's license regime.
Counsel, going back to a question that I asked earlier, does it matter that the Kansas Department of Revenue has adopted this formatting convention that is used across the United States, that even though the statute says gender, the driver's license itself says sex, and then what follows is what we would traditionally think of as a biological sex that follows that?
Well, I don't think that we would traditionally think of it as biological sex, Your Honor. And I think that, to my point that it doesn't matter whether you think sex and gender are interchangeable, I think that also explains the license distinction. I mean, I agree with my friend at Cador that the fact that the licenses use the term sex on the face of them does not render them a statute, rule, or regulation covered by SB 180, and they can't change the underlying law of the driver's license regime. But I think the fact that, both Cador and, in fact, the Real ID Act recognize that this could be up to states. States do it differently depending on which state it is. Kansas used to be among the vast majority of states that allowed people to put gender identity on their licenses. And I think that practice shows that whatever you think sex means or gender means, biological sex has not been understood to mean what Cador has been doing and what the driver's license regime would require.
Thank you.
Is there a difference between the term gender and the term gender identity? Because we seem to be using those interchangeably, and I wonder if there's a difference.
So, Your Honor, I think this is a point in the argument where I will say I really wish that our expert testimony had been admitted. That is, of course, another one of the errors we think the district court made below. But our expert was prepared to testify to how these terms interact with one another, and the fact that there aren't sort of readily this is one thing and this is another. So the Attorney General, for example, would point you to dictionary definitions. I think for how I understand the term gender, it could include gender identity. It can also include gender expression. So someone could be a trans man, but may not, to the outside world, may not express gender or may not be perceived as one gender. But I think that whatever gender means, to say that it applies to the SB 180 applies to the driver's license statutes, you would have to conclude that gender can mean biological sex only. Mm-hmm. And I would say with this argument about the limiting language in SB 180, this pursuant or applicable to an individual's biological sex, that is an argument that we have been raising throughout the course of this entire case. We raised it in the district court. The Attorney General ignored it there. The district court did not address it. We raised it in our briefs again in this court, and of course there's been no mention of it by the Attorney General response to it. So I do think that there is a very simple statutory construction approach to this case, and it is to say we're not going to fix the legislature's work. The legislature here used very specific language that limits SB 180's application, and whatever SB 180 applies to, whatever the outer perimeter is, we know it does not apply to a driver's license regime that uses only the term gender.
Counsel, aside from that fundamental point of your argument, how is your intervention different from the prior case that we just heard? Is there anything unique that we need to address in our opinion dealing with your case And if you would explain that for me.
Sure, Your Honor. So that is one piece of our statutory construction argument that I think is in some respects different from KDOR's. The other, of course, is that we have argued that to the extent this statute is ambiguous. Now, we think it's clear in foreclosing the Attorney General's reading. But if this court disagrees and thinks there's some ambiguity, then one of the things that we have argued that is not in the KDOR briefing is that the court has to consider issues of constitutional avoidance. And there are, as evidenced by the many decisions around the country that have addressed very similar to constitutional issues to those we raise here, as evidenced by the I think, robust briefing in this case of difficult constitutional issues.
This is all the briefing in this case.
Yes, Judge Berger. So I think that alone really indicates to the court here, there are a lot of tricky issues. And to the extent
Yeah, I didn't, there,
There we
got
go.
it green again.
to the extent that this court could avoid those issues by interpreting the statute so as not to apply to driver's licenses, so as not to require this kind of forced disclosure of transgender status, so as not to force people to identify themselves to law enforcement, government agencies in a way that is inconsistent with their own gender identity. The court should do so if it possibly can. So we've made several.
Just speak up
Yeah, just
loud.
go on ahead.
I'm sorry.
All right.
I don't want to interrupt.
If only I were a few inches taller and wouldn't have had to move the microphone. I think that there are several constitutional angles, issues that have been raised here, and I would say the most straightforward for this court to address would be initially to address our personal autonomy issue that we've raised in the brief, and that's of course been recognized very recently by the Kansas Supreme Court and HOTUS. So the court has the benefit of this very recent decision, a lot of guidance as to what that right means.
How would requiring someone to disclose their sex at birth on a driver's license, how would that affect a person's personal autonomy? If you'd step me through that process.
Yeah. So I think HOTUS recognized that within this right of personal autonomy, there is a right to determine things for yourself. They call it a right of self-determination. I think part of what that is getting at is that you have a decision about how to live your life and sort of express yourself to the world. Now, obviously, that's not unlimited, but I think this self-determination facet of the right is one that is very much in line with what we are arguing here. Effectively, by forcing someone who is transgender to have a license with a gender marker that reflects only their sex assigned at birth and not how they identify, it would be like forcing someone who wants to put, let's say a statement about what they believe on the front of their t-shirt, and the government gets to put on the back a statement that says just the opposite. It is essentially taking the way that you would move about in the world, present yourself in the world, and negating it through a government document.
How is that constitutional argument? I've just been trying to figure out the contours of it. How is that different from, say, compelled speech?
So that's an excellent question, Your Honor. I think it is candidly not something that's been briefed in this case, but I do think of it in very similar terms. It is like a compelled speech argument. And in fact, there has been litigation in other parts of the country about, the extent to which the government can require inclusion of particular information on a license consistent with compelled speech. I would note, one interesting thing about this statute in 8 section -243, so that's the section of the Kansas statute that says you have to have your name, your residence, the kinds of information that can be laid out. That statute also has several types of information, such as veteran status, whether you need cognitive assistance, that someone can choose whether to have on their license or not. I think in recognition that these could be personal things or things that you don't want to say to the world about your background or your history for whatever reason. It also has a provision about identification of people who are registered sex offenders. And even for registered sex offenders, the balance that the legislature struck was not to require sex offender on their license, but to say that there should be some kind of number on there that is identifiable to law enforcement, but that would not otherwise, I mean, the implicit statement there is it's not going to otherwise out you to everyone who sees your license. So I think that there is this element to a license. It is not just what the government is saying, it's part and parcel of how you're presenting yourself, not just to the government, but also to private entities.
I'd like to go back to a question I asked counsel in the prior case, and that is, there's nothing to prevent the legislature tomorrow from introducing legislation to define gender in the way they want it. They're arguing it should be defined the same as they have defined sex. Is that then when you're constitutional? I mean, I'm assuming if that happens, then we're going to be faced with a lawsuit from your clients or similarly situated clients, then arguing that that makes it unconstitutional. And that's when these arguments about personal autonomy and everything would come into being. Is that, I mean,
well, yes, Your Honor. If
trying to think of what next steps are going to be in all of this litigation.
that may well be a case for another day that would be coming if the legislature were to take that step. But to the extent that this is what the legislature sticks with in terms of the statute that it's adopted, I do think that if this statute is ambiguous, there are still those constitutional concerns. And, you know,
In terms of this hearing today,
mhm.
do we have to address those?
No, Your Honor, there are multiple ways you could decide this appeal without addressing or even discussing those.
Because it seems to me we're here to see if there's irreparable harm proved or whether or not this needs to go further or needs to return. So do we really need to get into all of those details? Because it seems to me you're going a little far.
Well, Your Honor, you had asked how our position was different from Cador's, and so the constitutional aspect of our argument is certainly distinct. But
You're
I
telling
do
me
want
it's there
it's
and-
different.
and could be exposed in the future.
That's correct and should be a tool of statutory construction to the extent there is ambiguity here. But I do want to talk to your point about irreparable harm because you raise an important point. A preliminary injunction, as you said, is supposed to be extraordinary relief. At this point, we are roughly a year into an order that has effectively precluded transgender Kansans from getting licenses that accord with their gender identity as they had been able to do under the long established status quo. And the basis for that, the governmental interest that would justify that, I think is quite remarkable. I mean, the Solicitor General said this morning there are 3 irreparable harms in response to Your Honor's question. One is that the legislature, you know, the state is harmed anytime it does not enforce or apply the law. Well, if that's the case, I mean, nothing would stop the Attorney General from coming in and suing all sorts of agencies over any law, simply on the theory that his reading of the law is inconsistent with the agencies and they're not complying. That is not an irreparable harm sufficient to satisfy a preliminary injunction standard. The other harm that he identified was that it's hard to claw back licenses. That's not really a harm. I think that goes to whether, if there is a harm, is it irreparable? You know, I don't read the statute to say that it would be impermissible to have some kind of temporary license that would, you know, allow people to go forward. And if something changes in this litigation, then, you know, there may be a change in their license. But even so, that argument of harm really depends on his assertion that he's right on the merits, which again, we don't think he is. So that really leaves us. He gave 3 irreparable harms. One is they're not following the law. 2 is we can't claw back licenses, and that's harmful if they're not following the law. And then the third is essentially there is this one statement in the record that someone, a law enforcement officer, was confused about an individual's criminal history. And when the individual's sex assigned at birth was used, it sounds like in the search for this person, that at that point, they identified the person had a criminal history. But the bottom line here is that the person was arrested. The person was in fact housed and went through the process. That alone is not sufficient to justify what we have here of an injunction that is prohibiting transgender Kansans throughout the state from getting their license. And I think to the point about the status quo, again, it's not Kansas where it has been the law or the rules that people could get a license consistent with their gender identity. This is true in the vast majority of states. And so the fact that the Attorney General cannot identify a single instance of true harm to law enforcement, I think shows that the district court's order in this case is simply not sustainable, even if the court looks, to your question, Judge Hill, only at the irreparable harm or looks first to the irreparable harm.
Thank you.
Council, I've allowed you to go probably an extra 5 minutes, but that's because we've had lots of questions. So I want to make sure, are there other questions from the panel? All right, then
Great.
you still have your 5 minutes for your rebuttal.
Thank you.
You're welcome. We're a softer, kinder Court of Appeals this morning.
There's a new chief.
Good morning, Council.
Good morning.
Good morning. May it please the court.
I'm going to start out with one question.
Fire away. Fire away, Judge.
And that is, as you can tell, we've asked a lot of questions about irreparable harm. So I want to go back to this. The one I'm having trouble with is the first one you mentioned, that if the Attorney General determines that an agency is violating the law, then that in itself is harm. Do you have other cases around the country that say that, or would this actually be a new law that we would be saying as a matter of law, basically, that if an agency is conducting itself in a way contrary to the interpretation of the law by the Attorney General, then a temporary injunction would be the appropriate way to get that to stop, rather than just a regular lawsuit that doesn't have injunctive relief? Is that a
Well,
long question?
let me answer it this way, because it kind of goes into the relationship of the Attorney General
Right.
and the other departments of the government, and why we do AG opinions, why that's in the law, why we're asked for authoritative, because it all boils down to, under the Constitution, we speak for the state in court. We're charged under the law with enforcing the law.
Mhm.
And our position in our brief is that it's intolerable for an agency of the state. They're the servants of the people, and the people have said, you are to do A and B. And the department takes it upon itself to say, we're not doing the A and B because we think you're wrong about that. That's what makes it a serious matter. And it's why the law provides for the Attorney General to provide AG opinions to the organs of the government, and why it carries persuasive weight with the organs of the government, because this is what we say we think the law is.
And do you
And
have
it always carries with it the risk that if you disagree, that we're going to go to court to ensure the enforcement of the law. And the law also allows for, and what we did here, we brought a relator action. So we're bringing this action in the name of the people, in the name of the state.
right?
That's what makes this
So what
different than your
cases
garden
have-
variety.
Any cases that this has been an acceptable position around the country?
I think
or
it's
would this
been,
be the
I
first
think
time?
relator actions, I think the Kansas reports are filled with relator actions where the Attorney General's gone to court to
No,
sue.
that's not what I'm talking about. I'm talking about a finding that the mere fact that an agency is interpreting a statute differently is irreparable harm. Are there any
I
cases?
think we cited some in our brief. One
Okay.
isn't coming to my head, forgive me,
All right.
Judge. But I think we cited some of those key
Okay.
in our brief, that say that it's a sort of an intolerable situation.
But to be clear,
Yes,
each state agency is obliged to obey the law.
yes,
And the Department of Revenue, the secretary is obliged to obey the law as that agency perceives it until told otherwise, correct?
true.
And you also used
But it's an extraordinary thing, Judge.
persuasive. Attorney General opinions are to be persuasive, and that's why we have them, to persuade them. But if they disagree, you have to do the relator action, don't you?
Yes,
And that's why we have them.
yes.
Okay.
Yeah, that's true.
Counsel, I wonder if you could, and since we're not going to let you have any of your regular arguments, I'm wondering if you could address the argument having to do with this language with respect to the application of an individual's biological sex. How do we interpret that?
Well,
The
it's an
biological
interesting,
sex.
it's an interesting argument that they've made, and I think we haven't addressed it because quite frankly, not understanding the limiting principle, because the whole purpose of the definition of sex that the legislature gave, of course, refers to biological sex. And our position is, and it's been from the beginning, that gender is synonymous with sex, which means it deals with biological sex. So that's why we think it's encompassed within Senate Bill 180. The other thing, though, is that the clause right before that, where the legislature says, notwithstanding any other provision of law, that tells me that the legislature was intending to make a broad swath, not a narrow one, as the ACLU would suggest, or interveners would suggest. And so I think that's significant there too. And I think that is also supporting of our argument that wherever sex appears, and in this instance where gender is synonymous with sex, you have to use the biological term of sex from birth as defined in Senate Bill 180.
Would this be a different lawsuit involving different arguments if the driver's license itself said gender and not sex?
No,
Why not?
because it's our view that gender and sex are synonymous. I think the fact that the face of the driver's license says sex supports our position that they're one and the same, because the statute says the driver's license shall have on there the gender of the person, but the license itself says sex.
So in your
That's a
view-
pretty clear
so in
showing
your
that
view,
they're the same.
The language on the driver's license is evidence, but it's not of any import in and of itself.
It shows that the department also has taken the view that sex and gender are the same, because the statute commands the Department of Revenue to put on a driver's license the gender of an individual, and the department has instead put on there sex and it's M or F. And it's not gender identity, which can be, there's the whole range of what gender identities might be. It's not that.
And which sex you put on there, male or female, is also described in the statute. What you define male and you define female,
Correct.
right? Or the
Correct.
statute does. And yeah, I may be going down a rabbit hole here, but I have a question when it says a female is an individual whose biological reproductive system is developed to produce ova, and male reproductive system is developed, meaning it seems like a full, completely thing, not designed to, but is developed to fertilize the ova. So what if you have a female whose reproductive system never developed to produce ova? How would that person, what is that person? Or their male's reproductive system is not developed to fertilize the ova. I'm just, the present tense of is developed makes me wonder what if you have a male or a female that their reproductive system hasn't developed in that way? What are they?
Well, those are extremely rare, is my understanding. No, I'm not an expert on it.
I'm not an expert either, but
Quite frankly, I'm not sure what the right answer, to be truthful to you, Judge. I think the legislature is trying to speak to the broad range of reality out there and how we determine and, the sex, biological sex of a person. And it really comes down, they're trying to make a straightforward, I think, explanation. They're not accounting for what some of the very rare exceptions might be.
But we have to deal with the language of the statute, and when we have present perfect tense is developed, it means is developed. I mean, at that point. And so that's what we have to deal with, and I think the import of my colleague's question there is, if that doesn't happen, what happens? Should we consider that at all? And that's, could you speak to that?
I guess my answer is no, I don't think you should, because again, they're talking about the whole entire universe out there. I suppose the legislature could have gone in and said, well, if this is the situation, then we should do this or this or this. And the legislature said, well, we're not going to get down into the weeds. They're trying to make an emphatic statement of the definition of a man and a woman in the general sense and in the definitive sense, without going into all, like I say, the particular exceptions
so
of
who's
that.
going to make that decision? So I go to the motor vehicle division and I say, well, my reproductive system has never developed to produce ova. What do you want me to put down? Is it just a discretionary decision as to?
I guess the department's going to have to come up with a decision, and
Okay.
if somebody doesn't like it, yes, you guys will end up
Mhm.
making the call.
Okay. Thank you.
Council, one more question. and
Sure,
That is,
sure.
we've been talking a lot about A, subsection A. I want to talk about subsection C.
Okay.
Is it the Attorney General's position that subsection C also sweeps the Department of Motor Vehicles under subsection C with regard to the vital statistics
Yes,
provision?
yes. Our view is that the driver's license record, which keeps all this identifying information, is like a vital statistics. And it's a record that's kept. It's used for statistical and all sorts of purposes. And so, yes, that's our position, and that's what we said all along. And so the department, in our view, since they're recording that information, they have to report the information in their database of biological sex at birth for each licensee.
And that it doesn't matter that it's kind of a reverse kind of reporting. It's unlike vital statistics where that information is kind of entered from the get-go. You have information that it kind of trickles down through the driver's license process. Doesn't matter in your
Well,
view.
the department gets that from your birth certificate, which is, of course, generated from, observation of the doctor at your birth. So it kind of starts from there and flows through to the driver's license record. So I would say it does start from the beginning.
Thank you.
Let me address, I guess, this issue of harm, and maybe we've already beat it. Maybe you guys are satisfied
Well,
with
let me ask you a
about the
question.
irreparable harm issue.
Let me ask you a question, because I asked your opposing counsel. In your view, this case has unique arguments that differ from the earlier one. What is your position with respect to her answers to my prior question?
Well, simply put, it's the state's view that no one has a constitutional right to demand that the state put on a state document their preferred gender identity. That's our position on that score. And so we think the constitutional arguments don't carry weight for that reason, and why you don't have to apply any sort of constitutional avoidance.
And that
I simply
wasn't,
think
that wasn't argued below.
It was rejected below by the district
Rejected,
court. The
right.
district court said, you don't have a constitutional right to have your preferred gender identity put on a driver's license. And other courts have said that, And I think that's true. I think that's really the bottom line argument, is you just don't have that. They couch it in different terms. They're trying to grab from privacy rights or autonomy. No one's autonomy is being interfered with here. Transgender individuals can live as they want to, but the state has said we want accurate and consistent and reliable data on our driver's license, and they want, for the reasons I've talked about earlier, we want biological sex listed on a driver's license. And I think there are very good reasons for that. As I've said, for consistency, for authoritative, because the alternative is, if we go down the gender identity route, this court says, well, you've got to allow a person to put their gender identity, then it can become a fluid thing, and it can change, multiple times. And I think that's a problem. I think the state has the right to say, that's not how we're going to do this. I think the state has the right to say, this is what we want, biological sex on a driver's license. And I don't think that compels any transgender person to do anything. At the bottom line, now we may agree or disagree with it, but it's always been the rule that obtaining a driver's license and the right to drive, there is no right to drive. It's a privilege to drive. And so I guess at base level, a transgender person doesn't have to get a driver's license if they think that obtaining a license and having their biological sex on it is so upsetting to them. I guess they don't have to get a driver's license, but the state has very good reasons for doing what it did. And that's what I think that's a sufficient rational basis for this. The court doesn't have to agree with the policy. I don't have to agree with it. Obviously, interveners don't agree with it, but those are policy arguments that they all made in the legislature at the time. I mean, I went through the testimony and they made very strong arguments. They said it was discriminatory,
Counsel,
at length.
and I'd like to talk a little bit about the district judge's decision with regard to the constitutional arguments,
Okay.
because the very last analysis was the analysis of equal protection. And it seemed as though the district court was saying that if you just look at the Senate bill itself on its face, that bill does not create a classification, and thus we engage in no equal protection analysis. But I think that we often look at the application of a statute and see whether it treats similarly situated people differently. And that's the crux of equal protection. And so I'm wondering if you could speak to the rationale behind.
Treats similarly situated people the same. It doesn't matter whether you're a man or a woman. You have to put your biological sex on your driver's license. Transgendered individuals have not been considered a suspect class in this state under the law. It's been rejected by a number of federal courts, including, we cited Gore versus Lee, which talk about this issue. And so it's permissible for the state to use
I want to,
sex as a criteria.
Counsel, I just wanted to be clear. Are you saying that similarly situated people are treated the same, and thus there's not an equal protection problem? Or as the district court found, there is no classification, there is no differential treatment? I think that there's a slight difference there.
I don't think we're saying different. I think that's what the court was saying, was there is no equal protection problem because people are not treated differently under the statute and under what we've demanded that the Department of Revenue do, which is to list your biological sex on your driver's license. That is the same for everybody. It doesn't matter who you are. You have to list your biological sex on your driver's license. That's why there's not an equal protection problem in our view with that. And other courts have found that. We've cited to those in our brief. I do want to address real quick, because you asked the question about compelled speech. It's not compelled speech because a driver's license is it's government speech. It's not the speech of the person or the holder of the driver's license. It's the speech of the government that's put on the driver's license, because the driver's license is a government issued document. And so that's why it's not compelled speech. And
Is there
courts have held
no
that.
speech that occurs if someone hands a driver's license to a person, like once you've had you have the driver's license, you hold it and you hand it to someone who has asked for it,
No.
you're not speaking.
No, you're not.
And
Courts
are
have
those
said that
cases in the?
in our brief.
Okay.
Yep. Any other questions? I'll sit down. All right. Thank you very much.
Very much.
Thank you.
Counsel, you have 5 minutes for rebuttal.
Thank you, Your Honor. So I want to begin by picking up where the conversation just left off on the constitutional avoidance arguments. Of course, Your Honors don't need to reach those, and certainly don't need to decide them. The whole point of the constitutional avoidance canon is that you don't have to decide difficult constitutional issues. I will say, though, Chief Judge Warner, to your question about the equal protection ground, I do read the district court's opinion as holding at step 1 of the equal protection analysis that there is no classification in this law, which of course, under Kansas Supreme Court precedent can be shown either on the face of a statute, which we think this one does, and in terms of its operation. Again, we think that this SB 180 is a sex-based, transgender status-based classification, and you can get there on sex from just looking at the statute. The way that you tell that this is a sex-based classification is to swap out the sex of a person and see if the result changes. If my client, Mr. Kellogg, had a birth certificate that indicated male at the time of birth, he would be entitled to a birth certificate that reflects that he is male. But because he has a birth certificate that indicated female, he cannot. If you swap out the sex of the person, the result changes. It is a sex-based classification. I would also note that this argument about equally applicable, this sense that if a law is equally applicable and harms men and women the same, it is as it goes, that it cannot violate equal protection, goes against decades of constitutional precedent in other states, in U.S. Supreme Court case law. I mean, certainly think about the case of Loving v. Virginia, the anti-miscegenation case that barred interracial marriage. That applied equally to white people and Black people, but there was no question that that was a race-based classification. So I do think you can avoid these issues. We've cited a number of cases in our brief from other jurisdictions where, to the extent that these issues about equal application or what is a sex-based classification, there are other guides out there from other jurisdictions. But I think it's enough to say that interpreting this statute in the way that the Attorney General suggests would very much call into question the statute's constitutionality, and an interpretation of the statute that would avoid those difficult questions should be adopted if at all possible.
Would you respond to my perhaps rabbit hole, but question about the use of present perfect tense in the definition of female and male? Does that add ambiguity to the statute, or you have anything to say about that?
In response to your question earlier about gender, I was looking at what is in the record on that, and I would direct Your Honor in terms of these questions about how the language of SB 180 lines up with what a medical professional might think of these terms. I would direct you to the Dr. Aller's offer of proof, which is in the appendix to our brief at page 77A. And she does talk in there about this idea that the term sex, biological sex, is not a medical term. It is not understood in medicine as sort of one single thing, although the Attorney General would have you believe otherwise.
That was just a proffer. That's not part of our evidence.
That's correct.
Determined that she should have been allowed to testify.
That's correct. That's correct. I think that, as I said earlier, I do think the statute is in many ways not well drafted. I think parts of it are clear in not applying to the driver's license statutes, but I think what you're pointing to is perplexity or perplexing. I think at bottom, perhaps the best way to respond to that is that it is an indication, like the rest of SB 180, like the other statutes adopted in that very same session targeting transgender people, that this is an attempt to write them out of existence. The argument of my colleague here that Kansans could simply avoid getting driver's licenses if they don't like the impact of the district court's order should be rejected out of hand. I mean, in just the past week, I've been thinking about this, using a license at the airport, at a hotel, to get into my child's school. All of these myriad ways that people have to use some form of identification. And the driver's license, as we all know, is presumptively the one they use, and in fact is legally required if they are driving. There is, I believe it's 8-244. You are required to carry a driver's license if you're driving, and required to present it if you're pulled over.
About if you got, and I haven't looked at this, but you would get a real ID identification card from where? From the DMV as well, or? Because you have to have this real ID identification to get on a plane, basically, or your passport.
Correct.
Okay, so what are the requirements on a passport? Does a passport have to say your biological sex, and where in Kansas do you get an identification card? And does that have to, is that also lumped into this, or do you know?
So my understanding is that there may be alternative ways to get an ID that would comply with real ID, but for the vast majority of people, they use their license because
But
everyone has it.
right, but I know
Right.
there is, you can get a state issued ID. I'm just not sure does the DMV issue that too, or?
I don't know, Your Honor. But as you mentioned, the passport option is not in fact an option for, the numbers are not in the record, but I think it's safe to assume the majority of Kansans do not have passports, which is pretty consistent in most places around the country. So that's not realistic. And even if it were, of course, people use their license. It is ubiquitous in daily life, both with interactions with the government and with private entities. So if
Any other questions from the panel?
Thank you, Your Honors. With that, we would ask you to reverse the district court's order. And as mentioned in our briefs, in light of the ongoing harm to our clients, to transgender Kansans, we would also request that issuance of the mandate come with a reversal of that order to put a stop to the ongoing harm to our clients. Thank you.
Thank you very much. And thank you to all the council for your arguments today. Very interesting arguments. We'll take these matters under advisement and we'll get a written opinion out as soon as we're able.